So I wanted to start from the very basics. There's a couple of threshold questions that you need to ask yourself when it comes to determining whether you're subject to HIPAA or not. Number one, who is involved? And number two, what types of information is collected or used or generally speaking involved? First, threshold question, who is involved? I call it like user-centric approach. The meaning is HIPAA doesn't really cover products per se. So it's not so much about the type of application. It's really about two things. Who collects and uses the information, and what type of information is used and collected and shared. I'm sorry for bringing up all of these legal definitions and legal concepts, but it's really key for getting a better, a basic understanding of HIPAA. The first category, extremely important, covered entity. I'm sure you heard about it. Generally speaking, it must be either a plan or a healthcare, health plan or a health care clearinghouse, or a healthcare provider that transmits. It's going to need to be electronic transmission of health information, and we'll talk more about it. The second legal category, extremely important, also business associate or BA. Everybody that performs a function on behalf of a covered entity that involves the collection, use, or sharing of personal information in the health space, as defined, as we will talk about later, will be qualified as a business associate. And then the other key question, what type of information? So from a privacy standpoint, there are three different legal categories when it comes to information. The first one, PHI, protected health information. This is the HIPAA universe. This is what counts for HIPAA purposes. The second one, PII, personally identifiable information. That's kind of the broader set. All information that belongs to an individual that identifies somebody as an individual. And then the third category, non-PII, other information that might originate from an individual, but it doesn't identify somebody as an individual. It's really relevant because PHI is the HIPAA universe, as I said. PII isn't necessarily relevant for HIPAA purposes, but it is for general privacy purposes. And non-PII, generally speaking, isn't relevant. However, we will see that even the collection use of non-PII may be subject to regulations. So let's go back to the definition of PHI, which is really what you guys need to pay attention to here. Protected health information. Information that relates to the individual's health or condition, the provision of health care to the individual, or the payment for the provision of health care to the individual. You see the two common denominators, individual and health. So it's got to be information that relates to an individual, and it does have to relate to health care. A couple of case studies to try and implement the legal concept that we talked about. The first case. This is an application that collects individual workout data. There's potentially PII here. If it's individual workout data, there might be a lot of data associated with a particular individual. Right? It might even be relatively sensitive data. Think about data that reveals patterns or the routine of a particular person. If it's about fitness and doesn't involve medical care, we have PII, but we don't necessarily have any PHI. So if there's no PHI involved, it doesn't matter that this is individual workout data. HIPAA doesn't apply, not a problem. The second one, different application that collects data. It might be from individual users, but then the data is provided to a physician on an aggregate basis. Think about charts, graphics, statistical data of different kinds. This is a little more interesting because you have data that might originate from an individual, but it's provided to a physician, though only on an aggregate basis. Legal consequence, no PHI, no PII. HIPAA doesn't apply. The third one, I think, is a little less intuitive, probably more interesting. Different type of application that involves monitoring. Think about like one of the many apps that allow people to be reminded about taking certain medications. So there's individual users. There's information that might relate and is likely to relate to the health condition of the person. However, there's no physician involved. So we have health-related data. We don't have any covered entity involved. PII potentially, no covered entity. HIPAA doesn't apply. I'm raising all of these issues because it's interesting how many companies like we talk to, like oftentimes they believe they're subject to HIPAA. They aren't, just because they don't meet the legal requirements. But let's make it more complicated. So again, let's go back. Application, data from individual users that may relate to the person's health condition, not provided to a physician. Let's make it more complicated, and let's throw a doctor into the mix. So this might be an app prescribed by a doctor, or just makes available data to the doctor for the doctor to use the data for medical care purposes. Big consequence. We used to have PII, like in the prior example, but now because the data is provided to a medical doctor, the data becomes PHI, therefore subject to HIPAA. It's a pretty interesting legal phenomenon where data originates from users, has a particular legal status, and because of the nature of the ultimate user, the legal status changes. And HIPAA applies. So what are the implications? There's a number of different implications. If you're a covered entity, well, number one, you're going to need to provide a privacy notice that in compliance with HIPAA. Number two, more importantly, there are very precise restrictions on the use and sharing of PHI. So the general rule is you can use PHI that you collect from a patient for treatment, payment, and healthcare operations in general. If you want to use the same PHI for other purposes, unless you fall under one of the very, very specific exemptions under HIPAA, you need written authorization. The default is these are things that are allowed. You want to do something else, you cannot benefit from any of the exemption. Written authorization is required. That was the kind of the privacy component of the HIPAA regulations. The second one is the security component, which would deserve an entire presentation, just for these bullet points. But the bottom line is, as a covered entity, you need to do a number of things to be compliant with the security rule, including risk analysis. You're going to need to analyze your internal operations and infrastructure and see whether there are vulnerabilities or threats, and see how to address them. You're going to need to document all of that, come up with a security plan, and then you need to implement a number of different safeguards, which may be administrative, physical, or technical in nature. The good thing about HIPAA, if you're looking for provisions requiring a particular company to adopt a particular type of technology, you're not going to find it there. The rationale under HIPAA, the security rule, is more about providing flexible standards and leaving it up to the covered entity to determine what makes sense or what doesn't make sense. One of the key distinctions is measures that are required versus addressable. Like encryption is a good one. It's only addressable, which as a legal matter means you don't necessarily have to implement an encryption method under HIPAA. It might make sense to do that, in which case you have to do that, but it might not make sense to do that, depending on the business model, type of data, type of sharing that you do. And then this is also important. I think it impacts the business model a little less, but it's very important in case of a security breach. If somebody gets unauthorized access to any of the PHI, there's an obligation to notify patients if the PHI is unsecured. This was for the covered entities, but we said if you are an entity that performs certain functions on behalf of a covered entity, then you might be deemed a business associate of the covered entity, in which case the statement, I'm not a covered entity, therefore no problem, is obviously not accurate. As a general rule, if you are a business associate and you are performing functions for the covered entity, you need to respect a number of different provisions, and you cannot allow to cause the covered entity to breach its HIPAA obligations. So in terms of the specific obligations that you'll be subject under HIPAA as a business associate, number one, you are required to enter into a business associate agreement with the covered entity, which is the agreement that specifies on a contractual basis all of the different measures that you're supposed to implement, or rules that you're supposed to comply with under the agreement. And then after HITECH entered into force around 2 years ago, business associates are also obligated to comply with all of the different safeguards that we talked about earlier with respect to covered entities, including the security measures that we talked about, and including notifying the covered entity in case of a security breach. So does it really matter? This is kind of a provocation, but what are the implications for a provider of a digital health app that falls under HIPAA because the provider is deemed to be a business associate? Well, number one, does it affect the company's monetization strategies? Maybe. It really depends on the business model. You can think of many, many business models which are very frequent in the space where you are providing a service to, say, like a medical doctor, right? Kind of the example that we talked about earlier. In that case, I see a very clear alignment of interest and needs in terms of both the legal requirements and the business needs. So maybe it doesn't affect your business model that much. If you are providing a service to a physician, you're not supposed to take the data and then spam patients with marketing materials about beauty products. It's really not the purpose. If your business model is different and it's really about monetizing data in a different way, particularly for marketing purposes, well, then you need to be aware that some of those ways that other companies in other spaces are using to monetize data might not be allowed in this particular space, which I think is something to pay attention to, because this is a space where, number one, there's a lot of data available, which is really interesting, really rich, that tells a lot about people's interest and people's needs, which oftentimes may be urgent needs, and therefore also, because they're urgent, maybe a little bit less price sensitive. And so there's a lot of temptation when there's data available and there's demand on the one hand and supply on the other hand that don't meet one another. There's a lot of temptation for companies to monetize. But what's okay in other spaces might not be okay in the healthcare space because of the restrictions that we talked about. It might not matter as a way of doing business in this particular respect. For companies like yours who might need to do deals as part of your business model with larger companies, think about apps that are really meant to provide a service to a hospital, an insurance company, some other big organization. As a practical matter, particularly with respect to security, but also privacy, I would expect, you're going to do deals with companies that have pretty stringent internal policies. So I think it's a practical matter in many, not all, but in many situations, when you're dealing with larger companies with their own internal policies, I think at some point, whether you are subject to HIPAA or not, and whether you've done the analysis and concluded that certain measures are or are not required, might not matter. Because at the end of the day, if you want to get a deal done and sell a service to a particular company, you might need to comply with their policy, regardless of whether you're subject to HIPAA or not. And then the other thing is, there are many rules under HIPAA that deals with complying with the formal requirements. But there are many other rules that really are the expression of best practices. Again, think about security. So whether or not you're subject to HIPAA, you might still want to implement a number of different security measures just to keep data safe and customers happy. This is the last point I wanted to make, and that goes back to one of the statements that we talked about earlier. I'm not subject to HIPAA, therefore I'm okay. I don't need to care about privacy. I don't need to care about security. And I said that statement is flat out wrong. Even if you're not subject to HIPAA, you are still subject to a bunch of different other privacy regulations in the US as well as outside of the US. COPA for collection of information from minors. Generally speaking, the FTC guidance for with respect to collection of information from everybody. And whether it's PII or non-PII, at the end of the day, looking at the FTC guidelines, you need to comply with the general principles of no dissent consent, which means you need to tell people that you are collecting certain types of data, and depending on the uses of the data, you might need to provide like an opt-out option, for instance. And also for a security breach, I told you, about the very specific rule that's under HIPAA, but there's a number of state laws requiring companies to notify users in case of a security breach. And then international issues, of course, if you're dealing with other countries with their own privacy laws, particularly the European Union with its own set of laws, then of course that's also something that you may need to take into consideration.